We are live.
We're streaming.
Yep.
Say hello, you Carl.
Welcome to the Summer Zoning Commission, Monday, October 4th, 2021, at 6:30 here in the Town Hall. We're going to do roll call. We have Paige Rathod, Dan Ferrero, myself, Jill Conklin, Jennifer, we're our staff liaison, and our county attorney, Carleen Delana. This is a continuation of a public hearing number 21-002, marking Karen Murdoch, 559 Mountain Road, Summers, seeking a special use permit for a farm, vineyard, and winery pursuant to section 6.12 of the Summer zoning regulations to allow for the operation of a tasting room, sales of wine, and consumption of on and off premises. So with that, you look like you want to say something, Sean.
No, I'm
Still in pain?
good. I'm good, go ahead.
Is your chair good enough for you? Do we have a better chair?
I wasn't bidding at the auction.
Do you need an armchair? There's some armchairs over there.
No, that's fine, should be okay.
So I think when we left off, we were waiting for Attorney Schoberg to present, or?
I'm thinking, Madam Chair, good evening, that there might be a housekeeping detail regarding the intervention petition, but I leave that to Attorney Landell.
Yeah, oh, sorry.
So, okay. You want me to come up and speak into the microphone?
Or I can hand you.
Here, you wanna-
if you want, or-
You want
just come up
here.
there, sure.
I'll slide over.
That's the hurdle I cannot make these days.
Okay.
It's only, I know it's only 2 feet off the ground. So for the record, Attorney Carl Landolina, representing the Summer Zoning Commission. I have a handout, which I'll share with, actually 2, with the members of the commission. And for the record, I guess, I'll leave the rest up here in case George, probably Sean may want one. Here's another one, George. There's 2. They may be somewhat repetitive, but
Oh, would you give me about 4 of these?
yeah,
Uh-oh.
but they were just gonna go on the edge of the table.
Oh, all right.
2 separate things?
Yeah,
You just give me one.
yeah, you're gonna get a second now. 2, 3. I think the first one you received from me probably looks like this, and it says review the petition. So that's actually the second page. I stapled these together myself, so you know they're backwards. So it should start, the first one should say, Connecticut General Statute 22A-19A provides that. That'll be the first page. So these are really just cut and paste from memoranda that I've done for other municipalities or clients when it comes to dealing with the 22A-19 petition. So I apologize if I start off with very basic information. I'm just going to assume that you've never seen one of these before, but that may not be true. I don't know. So there is a portion of the Connecticut General Statutes, a group of statutes known as the Connecticut Environmental Protection Act. It's called SEPA, and it's about 7 or 8 statutes long. It includes one section that we're going to deal with tonight is called 22A-19. That's the way it's sort of referred to in the land use community. And essentially, I'll read the statute to you, at least the first part. We can talk about the rest later. It says, in any administrative, licensing, or other proceeding, and in any judicial review thereof made available by law, the Attorney General, any political subdivision of the state, any instrumentality or agency of the state, or of a political subdivision thereof, any person, partnership, corporation, association, organization, or other legal entity may intervene as a party on the filing of a verified pleading. And we can stop there for a second. So that basically says that whether there's an administrative proceeding before the state of Connecticut or any local board or commission, which would include you folks, any person, partnership, corporation, association, organization, etc., all right, which includes the person in this case who's seeking to intervene, may intervene as a party on the filing of a verified pleading. Now, let's stop there for a second. So a verified pleading is just a group of allegations that are sworn to under oath, which you have before you in the petition. And in this case, which asserts that the proceeding or action for judicial review involves conduct, now this is the important part, involves conduct which has or which is reasonably likely to have the effect of unreasonably polluting, impairing, or destroying the public trust in the air, water, or other natural resources of the state. So that's the first section. So essentially what that means is that in any administrative proceeding, whether it be a zoning matter, a wetlands matter, I suppose it could be a Board of Education matter, if what's being proposed involves conduct, in other words, somebody's asking to do something, build something, whatever it happens to be, conduct, which is alleged to have a reasonably, which is alleged to have a reasonable likelihood of causing unreasonable pollution or impairing or destroying natural resources of the state. So that's the first part. So the person filing the petition must make some allegation that the conduct, and in this case, it is the conduct of applying for and receiving a permit to operate a farm vineyard under your regulations. That's what's being proposed. There's also, I think part of that application proposes the use of existing buildings, and there also is a plan, I guess, which includes the siting of a temporary tent on the site until such time as the operator sees fit to bring another application, which he may or may not do at some future time, to build the building as the sort of the tasting area. All right? So we have a verified pleading because it's been signed and notarized, and it makes certain allegations that the conduct proposed before you tonight has a reasonable likelihood of unreasonably polluting the air, water, or other natural resources of the state of Connecticut. All right, Part 2 of the statute says, the verified pleading shall contain specific factual allegations setting forth the nature of the alleged unreasonable pollution, impairment, or destruction of the public trust in air, water, or other natural resources of the state, and should be sufficient to allow the reviewing authority, you, to determine from the verified pleading whether the intervention, the petition in this case, implicates an issue within the reviewing authority's jurisdiction. For purposes of this section, reviewing authority means the board, commission, or other decision-making authority in any administrative licensing or other proceeding or court in any judicial review. So what this section is saying, the petition must set forth specific factual allegations as to how this conduct is going to unreasonably pollute, impair, or destroy the air, water, or other natural resources of the state over which you have jurisdiction. Okay? So i.e., if the one that I see most often in some proposals, let's say we're gonna build a distribution center. And someone might bring a petition, a 22A19 petition, and one of the things that they'll allege, this is a common allegation in these petitions, is that the idling of the trucks while they're waiting to leave the site or waiting to be loaded up or whatever, is going to cause an excess amount of truck exhaust to be expended into the atmosphere, and therefore is going to have a detrimental effect on the air quality in the state of Connecticut. So if you were a wetlands commission, you would look at your regulations and say, is there anything in these regulations that provides us jurisdiction over air quality? And you'd probably end up saying no, probably, unless you had some regulation that said we have jurisdiction over air quality. But absent jurisdiction over that specific allegation, that particular allegation should not be received by any board, because it exists outside of the scope of their jurisdiction. So there's the leading case on this is called Nazardo versus State Traffic Commission, in which the Connecticut Supreme Court said, we're not creating little departments of environmental protection in every town, or federal EPAs in every town, so that someone bringing a 22A19 petition doesn't open your jurisdiction on any and all matters that might be related to pollution of the environment. Only those matters over which you have jurisdiction. So if you don't have jurisdiction over the particular matter, it falls outside of the scope of your review, and you would not admit the petition to the extent, if that was a single allegation, that was something you'd probably say, we're not going to make you a party, we're not going to hear your evidence on air pollution, because we don't have any jurisdiction over air pollution. It's not within the scope of our review. The last paragraph says, in any administrative licensing or other proceeding, the agency shall consider the alleged unreasonable pollution, impairment, or destruction of the public trust in the air, water, or other natural resources of the state. And no conduct shall be authorized or approved which does, or is reasonably likely to, have such an effect, as long as, considering all relevant surrounding circumstances and factors, there is a feasible and prudent alternative consistent with the reasonable requirements of the public health and safety. So that means if there is evidence on the record that a matter over which you have jurisdiction, that the proposed activity is likely, in your review, to have to cause unreasonable pollution, then the next thing you would do is consider all other feasible and prudent alternatives. That's typically a word you would find in a wetlands regulation. If you've ever been to a wetlands hearing, they talk about feasible and prudent alternatives all the time. Generally, feasible means, can it be done from an engineering standpoint? Can we make this happen? And I think you could probably engineer a bridge that would go around the world. So, generally speaking, almost anything is possible or feasible from an engineering standpoint. But we have to include the word prudent, which means, you know, we wouldn't try to solve a small problem in Philadelphia by saying, well, the result or what's required is a bridge to go around the world, because that wouldn't be prudent, economically prudent, or prudent with respect to sort of an overkill of trying to resolve the problem. So first, what I suggest that my clients do, and when they're, well, let me go back for a second and talk about what some of the cases have said. So we all know what air and water are, right? That's pretty clear. We know what those things are. But then the legislature threw in, or other natural resources of the state. So there's been a line of cases when this act was first adopted over what does the legislature mean by natural resources? And they've gone back and forth. Usually early on, all these cases, when we were trying to decide what natural resources the legislature was intending to include, most of those cases went to the Supreme Court. One of the earlier cases is called Red Hill Coalition, with someone had applied for a subdivision on a farm. And someone filed a 22A19 petition saying, you're going to destroy the natural resource of farmland by allowing this subdivision to go forward. The Supreme Court ultimately said farmland is not a natural resource of the state of Connecticut. So they took that one off the list. A few years later, there was another case, I can't remember its name. They said that trees, however, are a natural resource.
That's Page,
Page, right, okay. Yep. There was trees and something else was a natural resource. So the court has sort of determined what natural resources are to the best of their ability, I guess. And there really hasn't been any, I don't think, substantive changes to the laws since any of those cases have come out. It still says, you know, the purposes of the act is to protect air, water, and natural resources. So now there are also cases that say that it is the burden of the applicant at least to put on a showing that, typically with some kind of expert testimony, because we're talking about impairment and pollution to natural resources, how the conduct, in their view, is going to cause, is reasonably likely, not just speculative, but reasonably likely to cause unreasonable pollution.
You're talking about the intervener, not the applicant.
The intervener, yes, did I say applicant? Oh, I'm sorry. The intervener. So, that's a case called Avalon Bay. But in any event, so what I typically like to do is to go through the specific allegations of the complaint, and for us to discuss whether we think each specific allegation meets the standards as set forth by this Connecticut Supreme Court. Thusly, is this a matter over which you have jurisdiction? And secondly, are the allegations factually specific? And the courts have said many times that a mere allegation that something is reasonably likely to cause pollution to the air, water, or other natural resources of the state of Connecticut is insufficient as a matter of law for you to engage on that topic. All right? So we look for very specific allegations. So with that, unless anyone has any questions, I think the best course of action would be to look at the petition and see what the allegations are. I think there are 5 of them which rise to the level of allegations. I assume everybody has a copy of this? The petition? This was handed in on the 20th at,
It was emailed.
Yeah, I didn't
Go
print
right
it.
next to the copy of the email.
does anyone, you don't have, I would prefer if we all had a copy and we went through it together.
Let me still make copies, I don't have a spare.
Okay.
Does anybody need a copy?
So while she's doing that, so if you go to my first handout,
CGS 22?
yeah, so at the
Yep.
bottom it says,
Oh, I have a spare.
oh, we need like 3 or 4 of them apparently, so. At the bottom it says, the commission must engage in the following analysis, and this is what we're talking about. Number 1, review the petition to determine whether it contains specific factual assertions alleging harm or possible harm to the environment. 2, determine the specific type and or character of the harm being claimed, and determine whether under the applicable wetlands or zoning regulations, the commission has jurisdiction over them.
Well, we're not addressing wetlands, because we're not a wetlands commission. are
Well,
we?
no, this is, I've written this for a
Okay.
more general
Okay,
audience,
all right,
not
thank
just
you.
you guys. But there may be instances where some towns have, a reference to wetlands in their regulations. So you'd have to go back and look at those specific regulatory provisions to determine whether or not, that's based upon the allegation, whether you really do have. Like you, for instance, as long as the language in your regulation doesn't go beyond the scope of your authority. Like if, for instance, if your regulation said that you have the authority to, determine the boundaries of wetlands, I don't care what your regulations say, you don't have that authority. All right, so if that was your connection to wetlands in your regulations, I would say you don't, that's outside of your jurisdiction, even if it is in your regulations. You go grab your set. I like those gymnastic moves, huh?
Yeah. Could that be in our regulations? I've never.
Well, I have picked out some sections which we probably should look at, but given that the regulations are only 4 months old, I'm not as familiar with them as
I'm not
some others might be. You know, we lived with the other set for 30 years, so I'm sure you had them all memorized, right? Or close there too.
If you're looking for wetlands, page 26.
What did you say?
Page 26.
Page 26?
What, your definitions?
Just some definitions.
Oh, yeah.
But that's, yeah, there's only 2 mentions in both
There's
the
only-
definitions,
There's only 2 mentions in the whole,
as far as I can.
okay, where was the other one? Right on page 26, or?
Well, I don't think it really matters because I don't think there's any allegations in the complaint.
About
of it-
wetlands?
About wetlands.
Oh. It's just a practice dry run?
Yes.
Yeah, that was just,
Thank
I
you,
was just
Debbie.
giving you examples because you didn't have the petition in front of you.
I'm like, I'm
sorry,
not
there
there.
are
I'm
no
not
copies,
there.
they're in the earthwork regulation.
Thanks for searching that document page. I know.
Okay, does everyone have a copy?
Yep.
Got it.
Yep, yep.
So, again, we're talking about whether or not you find that the petitioner has a right to become a party in this matter. This is a public hearing. So, you know, the petitioner, whether as a party or as a citizen of the town of Enfield or what have you, still has the right to speak and make his or her opinions known. All right, so this is, the only difference is, in this case, as a party, they have certain status if this was to get appealed. And I would submit it would subject them and other parties to sort of a cross-examination. But we'll get to that if and when we need to. So the first page, it says, number 2, the administrative proceeding involves conduct which has or which is reasonably likely to have the effect of unreasonably polluting, impairing, or destroying the public trust in the air, water, or other natural resources of the state in the following ways. So there is the allegation which must be made. And then what follows needs to be specific and needs to be something over which you have jurisdiction. So the first allegation, the plan submitted with the application failed to show the location of the buildings and a proposed tent on the property. All right? Now, we're not going to talk about whether or not these allegations are proven or not proven. what we wanna talk about, because I don't know if this is true or not true, and it doesn't really matter. The question is, does that in and of itself, that's certainly something you have jurisdiction over, but based upon that, is there any way that the intervener, through some testimony or evidence, can say that the failure to do that has a reasonable likelihood of causing unreasonable pollution to the air, water, or other natural resources of the state of Connecticut? Now, I have my view, but that's not important. So I guess my first thing would be to say, okay, but what natural resource are we talking about? Because if we're talking about air pollution, we don't have any jurisdiction over that. It's not clear to me, and you know, I think we should give the applicant, when we're done sometime, or, excuse me, the petitioner and the applicant perhaps to give you their views on that. So let's set that one aside for a second, if we might. All right? Number 2, the plans submitted with the application fail to show any drainage or erosion or sedimentation controls for any construction activities or any use activities on the property, including but not limited to the proposed tent. All right, so you do have, obviously, control over drainage, erosion and control, sedimentation controls. But how is the fact that the location, or I'll have to let the intervener speak for himself on this, but what you're gonna have to ask yourself is, does the fact that there's a tent proposed, which you would obviously have jurisdiction over the siting of that tent, how is the lack of any drainage information likely, reasonably likely, to cause unreasonable pollution to the air, water, and other natural resources? And if so, what natural resources are we talking about? And once we find out, do we have jurisdiction over them? And it goes on to say, is that likely that stormwater runoff may unreasonably pollute, impair, or destroy the public trust in air, water, or other natural resources? And again, I would say, what natural resources are we talking about? As I explained to you early on, the claim that something is going to impair or destroy the public trust in air, water, or other natural resources, the Supreme Court has said, is not factually specific enough such that the administrative body would be reasonable in granting status to a party based upon those very non-specific allegations. So number 1 and number 2, we're unable to ascertain at this point, in my view, what natural resources are we talking about, and if we have jurisdiction over those natural resources. C, in the spring of 2021, the applicants regraded their adjacent property where they planted grapevines. They installed no erosion or sedimentation control. They graded the property in such a way that the water runoff sheet flows onto Mountain Road before it carries road salt and other pollutants, possibly including fertilizer and or pesticides, into Gillette's Brook. This problem persists to this day as the applicant's stormwater runoff continues to unreasonably pollute, impair, or destroy the public trust in air, water, or other natural resources, and there's a photograph attached, I assume, of sheet flow. So, I guess my question or the issue I think you should inquire about, is this the same property where this proposed activity is going to take place? And if it's not conduct related to this application. And if it is, how is the activity that's being sought, or the approval for activity which is being sought through this application, going to exacerbate that problem? Now, factually, that might be very true. But if it's not related to this application, then to me, it probably wouldn't give rise to you granting status on this paragraph C, if that was the only allegation being made. So, again, there has to be a connection between the conduct being proposed and the reasonable likelihood of unreasonable impairment. D, the application fails to address pesticide and/or fertilizer application and control for the grapevines either presently planted or proposed to be planted. As such, it is likely that the application of pesticides and/or fertilizer may unreasonably pollute, impair, or destroy the public trust in air, water, or other natural resources. So again, we've got this very general allegation. It doesn't tell us which natural resource is likely to be impaired or how this commission has jurisdiction over it. And it would seem to me that pesticides and fertilizers are used on all farms, but that's for you to decide. Well, you can read that one for yourself and come to your own conclusions. E, the application with its significant increase in intensity of use on the property, inadequate management of stormwater runoff, significant noise and light, and increased traffic and congestion is reasonably likely to adversely impact wildlife and wildlife habitat. So here we have a very specific allegation. So we're off the broad, we're going to destroy the public trust in air, water, and other natural resources, and we have a direct connection between alleged activity and its allegation that it's reasonably likely to adversely impact wildlife and wildlife habitat. So I would say that probably, takes care of the first prong, in that it's a specific allegation. The next issue is, does the board have any jurisdiction over wildlife and wildlife habitat? So, and again, I didn't read the entire 200 and some odd pages, but I couldn't find one. Maybe the intervener can enlighten us, or the proposed intervener can enlighten us where we have jurisdiction over those things. So, does anyone have any questions at this point? I think we should probably hold our discussion until, unless you have any specific questions about the process, but perhaps, Madam Chair, it might be time for, Mr. Schober to maybe, fill in some of the holes or gaps that I see here with respect to the intervener petition. And again, this is not for him to give you evidence that there's going to be impairment. All right, this is for the proposed intervener to tell you why you should even consider these things, and allow him at a later time, once you accept or deny, or once you accept the intervener petition either fully or in part, then they would be allowed to present evidence that this is the reason that these things are likely to impair, reasonably likely to have an unreasonable, cause unreasonable pollution to the resources over which we have jurisdiction. So, you understand? I mean, it's not really a subtle difference, but, yeah, okay.
Yeah, so what we're doing is we're gonna let,
Yeah, I think
We're
Mr.
gonna let
Attorney
the
Schober
applicant-
say, the intervener say, why should we allow your client to be a party to this based upon these allegations that you've given us?
You can note that I'm marking these exhibits H and I
Okay.
for
the
record.
exhibit,
That's-
and this from,
Carl's handout.
the attorney,
Which
from
G?
Carl Lynn.
Your petition,
Ah,
So the petition is marked exhibit
G.
G.
Jill, are they the, sorry to interrupt, but are they the same things?
No,
They're different?
there are differences in them, yes.
just for the record.
And then the two
exhibit H
things
I.
handed out by the town attorney
Correct.
are
H and I.
H and I, exhibits H and I.
For the record.
Good to go?
Good to go.
Good to go. George Schilber, 352 Billings Road, I represent Ken Pryor and Michelle Pryor. So, why Ken and Michelle Pryor should be allowed to be interveners, and what we are stating the harm is, stems from Connecticut General Statute 8-2 and Section 1.2 of your zoning regulations, which tracks a lot of the language in Connecticut General Statute 8-2. So specifically, Connecticut General Statute 8-2 and your zoning regs in 1.2A statutory purposes state that your regulations are adopted to, 1, protect public health, safety, convenience, and property values. Number 4, promote health and general welfare. And additional purposes in B1, to prevent environmental damage and other dangers. B4, to conserve and protect existing and potential surface water and groundwater drinking supplies and other valuable natural resources. And number 5, to prevent unnecessary soil erosion and sedimentation. And that's the main gist of what our issue is the soil and the drainage. We have no ability to determine, because there were no drainage plans submitted with this application, what's going to be occurring up there as far as drainage and groundwater go. So we do know that there were grapevines planted on an adjacent property, but this application has to be considered as a whole, in that the other properties, in order to have a farm in Summers, you need 5 acres of land and at least 3 acres have to be planted. Now, the only plantings are 2 acres on the piece next to this piece. So we're here for a farm winery, and in order to have a farm winery, you need a farm. And in order to have a farm, you have to have 3 acres of crops planted. There are no crops planted on the big piece. There are 2 acres on the adjacent piece from which the sheet flow is occurring. So if you want to separate that and say that that piece doesn't count for this, well then it doesn't count towards their farm. But I think that the applicants have been very clear, at least in the memo that Attorney Clark prepared regarding the objection to our claiming intervener status, that all 4 properties are owned by Summers Mountain Properties, and it's one application. So we can't determine, based on the lack of detail in these plans, whether or not there may be, but what we can know, and we do know, is that there has been, and there continues to be, sheet flow. Now, the problem with that sheet flow, and Attorney Landolina, I think, said I should not be putting in evidence at this point, but we have emails from town staff regarding extra road salt having to be applied because of the ponding and the freezing from the sheet flow coming from the grapevine property that was planted on Mountain Road. And Mr. Pryor is going to testify, and we have an exhibit to introduce later regarding salt in wells. And Mr. Pryor is going to testify that the sheet flow has occurred and continues to occur off of that grapevine planting area. So that's the specific damage is to the waters, it's the groundwater drinking supplies, potential surface water, and you have jurisdiction over that based on Section 8-2 of the Connecticut General Statutes and 1.2 of your own regulations. Now, the wildlife is also a natural resource. The state of Connecticut, maybe not on this property, don't know, but the state manages wildlife. There are rules regarding wildlife, and our claim that an increased use here is going to destroy wildlife is certainly a reasonable claim. So, I will, stop at this point and provide you with additional information if you need it.
Thank you.
You wanna let Sean, Attorney Clark, speak?
So I, with all due respect to Mr. Schober in his position, I just don't think that, he's accurate as to this. If you look at the different, items that Carl went through in terms of the 5 different matters, my dad used to have this expression, he died 14 years ago, but he used to have this expression, and it took me until I was about 55 years old to figure out what it really meant. And he used to say if a frog had a tail, he bumped his ass, right? And everybody's gonna look and say, what does that really mean? And so, in this situation, as I look at these allegations, I don't see anything of a specific nature as would be required by the state Supreme Court in terms of the specific allegations as to what has to happen there. What we're talking about with respect to this particular property, we can just try to put it into context, is this is an application for a farm winery. You've all been here for the hearings in terms of the zoning regulation changes. But the application right now, as it currently stands, only entails buildings that have already existed or have existed at this property for quite some time. The only new part of this would be potentially
The heat.
oh, I'm usually the one that gets zoomed on, so I don't know if that's the case. But anyway, the only new part of this application for this particular hearing is with respect to the request for the tent adjacent to the tasting areas. As we submitted in our papers that I submitted to the commission today, clearly, my client made clear that the additional buildings were brought up and presented to the commission, so the commission would have an idea about what potential future plans may be, but that's outside the scope of what we're talking about.
That might be the microphones, I'm not sure.
You could switch out.
I would just turn these off now.
Is there too much feedback?
Here, I think it's okay.
I don't probably need the mic, but,
Top up.
so, in any event, I don't think there's enough specificity in terms of the allegations, in terms of that. I also think that if you look at the memorandum that we prepared and look at these activities, I would respectfully, apart from even Carl's suggestion that some of these activities, whether it's pesticide use, whether it's, the farming uses that are related to that, or even the wildlife uses, the statutory structure that's set up, and George mentioned 8-2, you can only make decisions that are things that are in your regulatory purview. You can't go and, as sitting as an administrative body here, for the purpose of this application, go and try to rewrite the regulations. All we can do is to basically look at it and say, does it qualify under the particular special use permit application that we're seeking? So in this particular situation, if you really look at the brief that we submitted, agricultural uses are not considered to be part of a natural resource issue. And as I pointed out in the memorandum that I submitted to the commission, if that's the case, well, let's look at the basics. This is a farm winery permit application. That application entails a farm use. As soon as my clients bought this property, and I noted it in the memorandum, they received notices that were liened on their property for all 4 parcels that are owned by some other small and pop properties that basically say, if you resell this property, you may be liable for taxes under Public Act 490, which gives it the agricultural status that it has and open space status that it has at this point in time. So the definition of farm in terms of the zoning regulations is met. They are actually growing grapes. They have other properties that are being used accessory to that. It's not just where you grow the crops, it's just the whole maintained use as a farm. So as we look at each of these particular allegations, again, they fail to show the locations of the proposed building of the tents. Well, we could show a location, but the commission could say, hey, we think that this location's better. You guys ultimately get to decide that. And quite frankly, if there's no issue with respect to air, water, or an agricultural use that's being made, I don't think the commission has jurisdiction to say that they have a right to intervene. The drainage plans and sedimentation control plans, some of that may actually be an issue for inland wetlands and not this particular commission. Next, the allegation regarding possibly including fertilizer and pesticides. There's no empirical evidence that anything, if anything's even been put down on the property, has caused any kind of pollution. So, when you file a verified complaint, you're filing under oath a claim that says, we believe that this is the case. You have to look at it with greater scrutiny. You have to look at it and say, are there the allegations in this complaint that says that's actually occurring today? And there's no evidence of that. So now, we're sidetracked. We're not even hearing, Mr. Schober's presentation about his opposition to this, okay? We're hearing whether or not they can actually intervene. And in this particular case, as I also know, there's really kind of not a big deal because Mr. Pryor lives across the street. He's already had the opportunity to speak at the hearing. He'll probably get an opportunity to speak through his counsel as well. And it's not like the commission's not gonna hear what he has to say. This just is one more way for the parties to engage in a dispute that's gonna unreasonably delay this particular hearing. And then we think it's inappropriate. The next thing with respect to, again, pesticides application and control of grapevines. Part of the charge here is that if the DEP regulates wildlife, well then let the DEP regulate it. That's not part of the zoning board's decision here. One of the things that they alleged in the first part of this was gonna affect the quality of life. Where does it say in the zoning regulations that this commission has the right to change the quality of life? And that could be very, very subjective. So we need more than that, and there isn't more than that. And quite frankly, we can't, for the purposes of this intervention petition, and I defer to Attorney Landolin on this, but we can't look at it and say, hey, now we have to have 3 hours worth of testimony on what this possibly might be, potentially might be, or may not be. It doesn't, the words aren't shall, the words aren't this is happening now, this is possibly, maybe, could be, should have, could have, but it's not, it is happening at this point. So it's just trying to sidetrack this particular hearing to allow this to move forward. And at this point in time, they're gonna be heard. They don't need to be parties to this hearing at this point. And basically, the commission should just deny the intervention application.
Thank you.
George Schober, I did want to mention that the commission absolutely has authority over soil erosion and sediment control, and that's in 7.6 of your regulations. And it's the purpose, this section of the regulations is intended to prevent or minimize soil erosion and sedimentation as part of any development activity within Summers. And there's general requirements. All developments shall establish, implement, and maintain soil erosion and sediment controls in accordance with the publication entitled Connecticut Guidelines for Soil Erosion and Sediment Control as amended. You're required, the special use permit and the site plan application also require soil and sedimentation control. There's a control plan required, that's 7.6C. A soil erosion and sediment control plan prepared in accordance with Connecticut Guidelines for Soil Erosion and Sediment Control as amended shall be required in conjunction with any application for development when the cumulative disturbed area is more than 1/2 acre. And again, the plans are so lacking that it was awful hard to figure out what's being done here. Until today, when I saw the tent that was sketched in on this tracing of a plan, I had no idea how big the tent was, but on Thursday morning, apparently, there was a new plan submitted, where the tent was, more or less located. But we have no idea what kind of construction is going to be needed to put that tent up. We have no idea how far around the tent. We have no idea. They talk about in their plans, and we'll discuss this later, in one of the narratives about improvements to sidewalks. I have no idea what that is. It doesn't show. The internal sidewalks from the parking lot apparently to various places. There's no details on that. But all of this makes it impossible to know exactly what they're doing and to determine whether or not, with certainty, whether or not they will actually pollute. We have a reasonable, either the plans are just so horrendously incomplete and it was just incompetence, or they're hiding something. Those are our two choices here, because we can't tell what's being done. So we believe that, well, we can't tell. The control plan, C2, the control plan shall identify proper provisions to adequately control accelerated erosion and sedimentation and reduce the danger from stormwater runoff on the proposed site based on the best available principles, methods, technology, and practices as found in the Connecticut Guideline for Soil Erosion and Sediment Control as amended. None of that was submitted, none of it. There's not even a plan, never mind does it comply with this. So, I mean, based on that, you can't approve this, based on that lack, but, you know, we have the right to be interveners under the statute, we meet the requirements, but I'll leave it to you. Oh, one more thing. And we were gonna be submitting this, later, but this is the assessor's new field card with Summers Mountain Properties as the owner. And the land on the field card, this is for the main parcel, the land on the field card is broken out as follows. Recreational, 1 acre. Tillable, 8.95, that would arguably be farmland. Woodland, 59.76, and swamp and ledge, 10.29. So I don't care what lien was put on, I don't care what the classification is, this is the classification for this piece of land, and it's not all farmland. So what Attorney Clark stated in his memorandum regarding that 22A-19 cannot apply because it's farmland is incorrect for two reasons. One, it's not all farmland, and two, part of our concern, a big part of our concern, is the sheet flow coming across Mountain Road polluting neighboring property. No farmer has the right to do that, even if it was all a farm, which it is not. Thank you.
We still don't have the evidence of that,
You don't
There's
have
still
any?
no evidence of any pollution.
Well, that would, for the record, Carl Andolina, that would come later, assuming you were to grant intervenor status on one or more of these allegations.
Well, again, Mike, just to quickly respond, that has to be in a verified complaint, so the facts are specific. I mean, you said yourself that Nazardo, that's what Nazardo was, so.
I'm not,
I'm not trying to argue with you, but I'm
Yes.
trying to make sure the commission's clear that he can get up and he can stand and he
Well,
can say this and that, but it's not clear. There's not specific facts that are out there. Otherwise, it's just specious allegation. Because there's no empirical evidence of that.
so these are some additional facts which I think you should consider. Can someone tell me how large the tent is? I'm sorry?
It's, 40 by 80.
You asked me to do math now, that's 3,200 square feet, right? Okay. See, Windsor-Locke's math is still good math. Okay. So we have to get through this issue before we take up, because it's going to, now, that doesn't mean that some of the evidence that Mr. Schober or his clients may want to introduce wouldn't be able to introduce it. It just means they wouldn't be able to introduce it as a party and as an intervener. And then you could, either way, you're gonna decide whether, they've introduced substantial evidence for you to rule that the regulations haven't been met, just like you would on any other application.
Mhm.
Or they're gonna, if as an intervener, they're gonna introduce evidence that you're going to find that based upon that evidence, there's a reasonable likelihood of unreasonable pollution to some natural resource over which you have jurisdiction. And therefore, you would be asking the applicant to propose, or you would discuss proposing feasible and prudent alternative to the proposal being made, which at this point, again, I'm not familiar with the application, so I know it's pretty clear that the application is asking for, the right to be considered a farm winery under 30-16-30E. No, 612 is your regulation,
Yeah.
but I'm talking, not 16, that's,
30-16.
30-16, I got them reversed. So that they would be able to get a permit from liquor control that would allow them not only to manufacture wine, but to serve it for on-site consumption in their winery, in their tasting area, to sell at local, farmers markets, and to do whatever else is provided for in 30-16E, which is essentially to sell by the bottle or glass for on-site consumption or retail. People could come and walk away with a bottle of wine, or sit there and drink their bottle. So that's the conduct that's being proposed, as far as I know. Again, the sidewalks, I don't know, is there a proposal as part of the application to redo sidewalks?
George is referring to, on-site, there's no sidewalks on Mountain Road.
No, I know, internal sidewalks, yeah, he was very clear on that, yeah.
There's no construction proposed in the application.
It's in the narrative
The
that was
walking,
submitted as part of the application.
There are no construction plans submitted in the application.
can I ask you a question, Carl?
Absolutely.
So, you're saying that we have to decide whether or not we let them in before we hear evidence?
Correct.
Okay,
It's a two-step process.
Okay.
And then you say, I'm gonna let you in with respect to allegation C,
yeah,
but no other allegations, and then it can present evidence to you of whatever they might have as to establish that the conduct that's being proposed has a reasonable likelihood of unreasonably polluting some natural resource.
This is several multi-page narratives that came with the application. Just wanna, look at that there.
Well, I assume you've gone through this, correct? I'm
yeah,
speaking,
yeah,
to- you
no,
know,
we've reviewed it
yeah.
for,
I don't know what's being asked for here.
I wasn't aware of any construction other than the tent. And I know there's, I mean, I haven't been up there for years, but I know there's like dirt paths or maybe the road, it says dirt road, you can walk, is that a path, is that where you walk around like a path?
It's on page 15, the bottom. We plan to make improvements to walking paths with the addition of stairways from the parking lot to the lawn area. This will prevent people from walking in the roadways.
Again, with the, as note, we only submitted like plans, we also have.
Is that-
capabilities.
Mark, is that this right here, like from the parking lot, is that already in place?
No.
Okay, so is it a downhill path where you go down a little and you have a couple stairs?
Right.
So that's something that would be built
Proposed
later
later in the future.
in the future, okay.
Well, that's the problem, it's in the narrative stating that that's gonna be done,
And
and,
so is the building, which we're not planning, we're not submitting at this time.
and the problem is that this property has a history of things being done without permits. And
The
if,
previous owner, you can't take that out on us.
So you're saying that that's part of the business plan, not the
So
application, or?
basically, I had sent all of you,
Mm-hmm,
the whole packet, and if you look, it does say, special use permit proposal for farm winery, and gives an executive summary, and then several pages in, mission statement, business description.
yeah,
Really, actually, it's probably something that the Murdochs should explain, not necessarily me, but it explains, I guess,
I want to give you an idea of what we have in the plan.
What they have planned.
yeah, yeah.
But again, this application is to allow us to open a winery. We're not asking for a farm, it's already a farm, we have a right to farm. We're asking to open a winery where we can serve. And the only thing we're looking to do is put a tent in because our building is too small to serve.
When you say it's already a farm, what do you mean? You're actually tilling crops on the property?
Yeah, we have 2 vineyards, we have a vineyard.
A vineyard on this site?
it's 4 contiguous parcels, it's all together. Which is exactly why the intervention, if that's the case, the intervention petition even, you know, Attorney Landolini, you had asked about, was it on this site where the sheet flow was coming from? So if it's one, you know, property, one application, contiguous, then that's why the intervention petition should be granted on that aspect.
The winery is located at 359 Mountain Road. That doesn't mean the farm has to be in the same area. We have gardens also, we also raise other things, so it's not just.
Well, the reason I asked that question is if you look at the definition of farm, which is a little bit unusual, it says a tract of land containing 5 acres or more with a minimum of 3 acres used principally for agricultural purposes.
Right.
It wouldn't be unusual to say, a tract of land or contiguous parcels, you know, this limits it to one piece of property. So I guess my question is this one piece of property or is it 4 pieces of property? And so I ask you again, what agricultural activity is taking place on this particular site?
We have gardens, we have hay, we have.
And it's not just where the crops are, Carl, it's also, you know, if you're running a farm where you're storing tobacco, right, the tobacco sheds are included, because that has an agricultural purpose. So, the buildings where they would make and produce the wine with respect to that part of it also is part of that agricultural purpose.
Well,
It's not just where the crops are.
here's where I would disagree with you, maybe we're getting off topic. It says principally for agricultural purposes. The farm vineyard is an accessory use to the agricultural use, so either it's accessory or it's not. So I'm saying principally. So the agricultural part of it has to be a principal use of the property in order for it to be considered a farm. But we're getting off topic, so.
We'll be getting to that later in the presentation.
Yeah, so I guess the question is, so you wanna go through these again? And then you can talk about them?
Yes,
Alright,
so,
so the plan submitted with the application failed to show the location of buildings and a proposed tent on the property. Alright, so even if that was true, I guess my question would be, and the question you need to answer, is that in and of itself, alone, standing alone, implicate any matter over which you have jurisdiction, which in any possible way, someone could establish that the failure to locate the building or proposed tenant on the property was reasonably likely to cause unreasonable pollution to any natural resource over which you have jurisdiction. I don't know, I'd like to hear your thoughts on that, I guess.
I mean, I'm gonna say now that the tent is located on the map, it wasn't before, it
Mhm.
was kind of like in that area, now it's located. I don't think a tent is gonna have any impact on a piece of land that size sitting in the grass. I mean, a lot of people erect tents, and I've never recall having them do a sediment or erosion control.
Well, now you're getting to number 2,
Well, I'm
but,
just
yeah,
saying that, I mean, we've approved tents before, and we've
Right.
just said, oh, do you wanna put a tent, yeah, put a tent there. But we haven't, this is new, but the tent is cited on the map now. This was referring to not showing a location, failing to show a location, which is located, so does that make that,
well, it may make it, at this point, factually incorrect,
okay?
but, whether it was correct or incorrect, the threshold question is, does the failure to do that, in and of itself, cause you to think that there's any way that the intervener could establish, based upon that failure, that there was a reasonable likelihood of the failure to show the location on the map causing unreasonable pollution?
I don't think so. You can ask, Mike.
The point's moot because
Well, he's saying
shown
if,
now.
if it wasn't, would it, do you think?
Well, that's the other point, it is moot at this point, but even if it wasn't,
I say no impact on the environment.
Yeah, I guess,
Or
if we were trying to
unreasonable.
avoid wetland areas or something, you know, I mean, we could.
Well,
go
that would be the jurisdiction of the
Yeah.
Wetlands Commission.
I mean, there aren't footings for the
We have
tent.
setbacks too.
I'm sorry?
We have setbacks from those places too.
Understood, yep.
But, again, it's moot.
All right, so B says the plan submitted failed to show any drainage or erosion or sedimentation controls for any construction activities or use activities, including but not limited to the proposed tent. As such, it is likely that stormwater runoff may unreasonably pollute, impair, or destroy the public trust in air, water, or other natural resources. So now we have the use of the word may, and I can tell you that the courts have said that these allegations and the proof related to them must be not speculative, but the words are reasonably likely. And again, we've got the standard allegation that this is it's unreasonably going to pollute, or may unreasonably pollute, impair, or destroy the public trust in air, water, or other natural resources. The intervener hasn't identified what those natural resources are. We heard salt getting into groundwater. But that's not stated there. So any thoughts on that?
Again, I don't think the tent has any, would unreasonably pollute or impair the site.
So let me ask you, under your regulations, when would you, I think I heard somebody say it, but I've forgotten, so when would you normally ask for erosion and sedimentation controls and grading plans?
Well, it's generally done through the building, through the planning, right, Jennifer? Through planning? I mean, we approve sites, but planning oversees construction,
No, but I'm saying,
subdivision
if
plan.
I was building a 30,000 square foot warehouse or a 1,000,000 square foot warehouse, would you require sedimentation and erosion control plans?
Yeah, for disturbed
in the
area
set?
when you're,
Yeah, so is there, I don't know, Jennifer,
Well-
maybe you know, is there a threshold? Or does the regulation say, anytime there's a site plan application, you have to show me ENS
There's a list-
controls?
Well, I mean, there's a
No.
list of what should be included.
Right,
And then the commission has, there's also, in the regulation that they can waive, so to speak, something that's not needed. So depending on what they're doing, I don't know, obviously for something like Henny Penny, we had erosion control.
well, that's
plans.
construction. I think if you're
Right.
gonna be constructing a building, there
Right.
would be all those things in place.
well,
And I don't know any farms that set up, silt fencing or anything
we're
for-
talking about the construction of it, or the
Tent.
erection of a tent, which is in fact a structure under your regulations. So I guess my question is there a standard,
For a tent?
not for a tent, for a structure of 3,200 square feet? Is that something you'd normally ask for? And again, this doesn't mean that you have to grant intervenor status. It may be something you may ask the applicant to provide to you. I thought I heard someone say half an acre. Was I hearing things?
Half an acre for what?
If there's, I'm just guessing that there might be some limitation or threshold in your regulations of when you are required to see ENS controls and, grading plans for.
7.6 is the regulation you're looking for, Carl.
Thank you, George. There's no limitation there.
Right, I don't.
What about in the site plan
I was just looking for that.
requirements?
Agreed.
I don't believe it mentions a threshold. Proceeding.
Appendix D. It refers to Appendix D.
And I don't think Appendix D is actually labeled, but it's the site plan
Checklist?
application checklist.
Yeah.
But at least what I saw online, there was no label. Utility services, engineering data, including drainage system, computations as required, it's on page 2. And erosion sediment control plan and narrative, and identification of specific erosion sedimentation controls.
But in answer to your question, Carl, I don't believe it sets any kind of threshold that would warrant requiring a waiving.
7.6 was the ENF stuff, right?
Yes. For drainage.
Oh, I don't know what to tell you. So again, just because of the fact that the failure to have that plan, if it's needed, may be a reason for denying the application. But we're not talking about the merits of the application. What we're talking about is whether or not failure to have that plan is prima facie evidence that there's a reasonably likely chance of unreasonable pollution to some resource, which is at this point, not named in the petition. So, now did you say also that the commission has the right to waive? But again, that goes to whether or not you think the application itself should be approved, or whether you want to move on to 3 or C while we think about B still? Or what are your thoughts on B?
Well, my thoughts on B are, like I already stated, for myself, I think a tent, we've approved many tents for different uses, and I don't ever recall going through any of this on any other application. I guess we could request a height of a tent,
how many poles are gonna go in the ground? Is there gonna be a floor? I mean, that kind of thing could, I don't,
The question that's being posed here today is whether
And
that,
natural.
the erection of this tent,
yeah,
All
okay,
right.
I'd say no to that, I
is
know what you're gonna say.
irrespective of what is,
The unreasonable
Yeah.
pollute, impair, or destroy the public trust in air, water, and other natural resources, no.
And if I could,
no, sorry.
Paige, you have anything to add, or Dan, as far as, I'm not speaking for the. for all
No,
of
I
us.
don't see where that's gonna be a problem on the, tent, you know, I mean, if there is, though, you can put it into the drawing, but, I mean,
I think there are, you know, as we said, later on, we could ask
Right.
for those things.
Mhm.
Because frankly, that layout leaves a little bit to be desired on a few levels in terms of a schematic, but no, I would move them to C.
Yeah, I mean, we could ask the applicant for, if they have a tent in mind, do they already own the tent, are they buying a tent, do they have a photo of it, what's the nature of the construction of the tent?
Is it year round, is it
Does
solid,
it stay up
is
just
it
for the
light?
season and come down? I mean, I know you planned on putting something else there down the road, the tent was gonna be probably for the summer and fall, which is almost gone. I just don't recall, so I don't know, I don't think this, is going to impair or destroy the air, water.
Well, not that you think that it's going to or not going to. I think what you're saying is that you don't think that the applicant can
yeah.
make a show of proof
No, I don't.
that the erection of the tent is gonna cause, any, unreasonable pollution.
And it looks like it's very far from the road, I mean, from this, I know it's a big piece, but it's quite far from Mountain Road, so I don't know any runoff on the top, up the roof of that would run down.
And the water areas, seems like
It probably might drain into these ponds before it gets to the road.
All right, let's move on to C. It says, in the spring of 2021, applicants regraded adjacent property where they planted grapevines, they installed no erosion or sedimentation controls, they graded the property in such a way that water runoff sheet flows onto Mountain Road before it carries road salt and other pollutants, into Gillette's Brook. The problem still, persists. So I guess the question for you is, how is the activity that's proposed here, which is essentially allowing them to call themselves a vineyard, a farm vineyard, and get a permit from the state, and the erection of the tent, how do those activities relate to regrading of an adjacent site? Or do they?
we're not sure. I'm not sure.
Whether it's an adjacent site, or,
I thought
I'm
the
not-
applicant said that it had happened in the past and it continues to happen, so it sounded to me like it was something that has been going on for years. Water runoff, I mean, we all know there's areas in town where water does run off onto the road.
yeah, like,
So,
again, I wanna try to get you to stay away from the actual proof of these
Okay.
allegations and just talk about whether or not, the allegation itself, excluding all other allegations, makes a claim over which something you have jurisdiction, and which can someone be able to convince you that this conduct, there has to be a connection between the allegation and this conduct that they're applying for.
and this is the one that would adversely impact wildlife.
No, we're on C.
Okay, so, all right, back to the same thing, impair and destroy the trust in air, water, and other. Can you show me where the grapevines are? On here, Mark? They're right over here, okay. So can you see them from the road, or
Mhm.
you don't, okay. So this road just comes further here and they're right here.
Yep.
And did the elevation of that land change at all, or did you just kill it?
We did some regrading last year.
what did
And
that,
I have pictures and we did have soil.
can you tell me what that entailed? Yeah.
It was a hill and there was a lot of trees, so we removed some of the trees and lowered so you don't have as much. If you had higher, you actually had more erosion, but we actually leveled it out quite a bit. And we did have soil, erosion, silt fence put in place while it was happening.
Oh,
I have proof of pictures of that.
So I guess the question, well, I appreciate those questions. The question is any regrading anticipated to erect this tent?
Did you move back up to B, or you on?
No, I'm on
Okay.
C, yes.
All right.
Because that's the
Is the
conduct.
tent
Again,
mentioned in
we
here?
have to, the
Okay.
tent's not mentioned in C.
C, okay.
We have to make, there has to be a connection between the allegation and the conduct that's being proposed.
Okay.
Now, this very well may be true. C may be true, factually true. And maybe that's an issue for an enforcement action or whatever. But the question is, how does this relate to what's being proposed in front of you today? Which again is the the
Yeah,
erection of a tent.
Tent in the wine vineyard, I don't think it does, it's already in place, it's not they're not here to install vines. We're here about the approval of the, application for a vineyard, winery, and the installation of a tent. And everything else is pretty much what's been there for years.
You guys have any comments or? Would there be consensus as to Jill's position?
What's that? I'm sorry.
Do you agree with Jill essentially?
Yes.
Yes.
Okay. D says the application fails to address pesticide and or fertilizer application and the control for the grapevines either presently planted or proposed to be planted. As such, it's likely that the application of pesticides and or fertilizer may unreasonably pollute, impair, or destroy the public trust in air, water, or other natural resources. Again, I would say that we don't have a specific allegation factually here. I mean, we've got an allegation of the use of pesticides and or fertilizers, but I suspect every farm uses those in some fashion. My understanding is that, again, well, I don't wanna talk about the generally are, if you use a pesticide or a fertilizer or in accordance with its manufacturer's instructions, generally speaking, my idea is that farmers have always been, allowed to do that. Obviously, times change. I mean, pesticides and herbicides that you could use 50 years ago have been outlawed, but so again, we have the broad, a non-specific allegation of an impairment to the air, water, or other natural resources. There's no specific connection made here between the use of this pesticide and whether that's likely going to impair some natural resource over which you have jurisdiction.
No, I don't see that. I mean, we all use fertilizer on our lawns, and I would think, with grapes, you're gonna be a little more careful. If you're making wine, you're not gonna use some, Roundup and glyphosate and kill all your crops. I mean, I don't see it. I don't see that impairing the air, water, or natural resources. So I would say no to that as well.
Would you guys concur with that position?
Absolutely.
All right, so letter E, the application with its significant increase in intensity of use on the property, inadequate management of stormwater runoff, significant noise and light, increased traffic and congestion is reasonably likely to adversely impact wildlife and wildlife habitat. If there is a section in this regulation other than, the introduction in section 1, which Attorney Schober pointed you to, that gives you jurisdiction over wildlife and wildlife habitat, I haven't seen it. I don't know if you've been able to find it,
Can you
or
put that
staff
in
has
the
been
word
able to
search
find
on the
it.
regs, wildlife?
I will tell you that the Supreme Court has held that, the statements made at the beginning of every set of regulations, all right, with respect to its purposes, that start off in every set in accordance with Connecticut General Statutes 8-2, these regulations are adopted for the following purposes, and those are right under the statute. And the courts have held that those are not, that language in and of itself does not give you jurisdiction over, well,
It doesn't say wildlife.
I know it doesn't say that, but it doesn't give you jurisdiction over everything. That just relaying, you have to find something specific in the body of the regulations, not in your purposes section, to make the connection between something over which you have jurisdiction in a 22A19 petition and something over which you don't. So, thoughts on that one?
Again, I say no, I don't see any connection. I don't feel it's gonna impact wildlife or wildlife habitat.
Well, then the question is not whether it's gonna impact it, whether you
they
have jurisdiction over.
No, I don't think they
Yeah.
do, no, I'm saying no.
You guys concur?
Right.
Thank you.
All right, so, I think at this time, we should probably take a vote, whether or not you're going to, allow the, petitioner to intervene as a party under 22A19. What I would suggest is that, maybe you have a recess for 5 minutes, and staff and I can work on some language,
Okay.
and then you can, officially take a vote on this.
Okay.
Can I
Yeah.
just, I don't know, excuse me, mention for the record, I had handed out at the beginning of the meeting, I'll mark it Exhibit J, but it
Yeah.
was the applicant's objection to the petition, so I don't know if they've had a chance
Yeah.
to look at that as well, or, I think that Attorney Clark basically explained it verbally, but I just wanna mark that Exhibit J and let them know before they vote that they have it.
Sean, would that be an accurate statement, that
I think
the
it-
gist of what
I
you're,
think it hit the most salient points.
Yeah.
I think, it'd be nice if we just take a quick look at it.
Sure,
The
okay.
Language on the agricultural stuff, I believe is important, but
do we have,
Yeah.
each of you have a copy of that?
I think she gave everybody copies of it.
They do.
Maybe we could read that now while you look at it.
Yeah. Well, during the recess? Okay, and it may change your view, so,
Where is that, Jennifer? It's not,
I handed each of you one at the beginning of the meeting.
I
It's
have
in your
it.
pile.
is that it right there?
yes.
Okay, that's where I can have it. Where it was. Okay. Is this our 5 minute, 8:01?
I think so.
I think you
Okay.
should read those during the hearing,
Okay.
even if it, to yourself, and then we should go off the record to, well, you can go off the record now, if you wanna take a recess and then, you wanna make that announcement?
Yeah, so 8:02, we'll be back here at, how about 8:10? Okay,
Yeah, I'm ready.
are we streaming again?
Mhm.
Okay, welcome back to the zoning commission, it's 8:15 and we're gonna continue our meeting. We were at the point where we were ready to make a motion on the, intervenor status.
So the commission, having reviewed the verified petition to intervene submitted on 9/20/2021 by Kenneth and Michelle Pryor, finds that the petition in its 5 claims fails to state any specific factual allegations over which the commission has jurisdiction. Therefore, I make the motion that the proposed interveners not be given status as parties pursuant to the petition to intervene under Connecticut General Statutes 22A-19, and that the petition not be accepted.
Do we have a second on that motion?
Oh, second that.
Okay, Paige made the motion, Carl seconded it, any discussion?
Dan second.
Dan second, what did I say, Carl? Carl, you're here in spirit now. Dan seconded the motion, any discussion?
I'll just mention that, during our break, I did have a chance to review the exhibit from Attorney Scott. Thanks.
Sean
Sean.
Clark, yeah. I also reviewed that during the break, and Dan did as well. So, all in favor of that motion? Aye. Okay, motion carries. The application is denied for the intervenor status.
We'll file another one.
We have a young lady here that wanted to speak at the public hearing, so you should, no. You wanna wait? Okay. Is there anything else?
Shall I just,
We're gonna-
if,
We're gonna,
I think we
Yep.
left off when we left off George was with.
At this point, I prefer to wait until the next meeting, and then let anybody else who wants to talk, because I am gonna go an hour. There's so much that is wrong with this. I'd also like Carl Walton here when I present.
Madam Commissioner, can I be heard?
yes,
I got a call during the break, I got a family emergency, so I'm happy with Mr. Schober going over to another date. I know my clients are not gonna be thrilled about that. We'd like to get this done obviously as quickly as possible, but I have to get on the road and get back to
Okay.
Glastonbury, so.
yep.
Before you go, so if that was gonna occur, is the next date outside of the 35 days, or?
No, it's not, we are,
One more?
I mean, I'm gonna make a motion that we continue this public hearing until, October 18th at 6 P.M., it's 2 weeks from tonight.
Could we, however, counter motion to do it even next Monday?
Well, next Monday's Columbus
holiday.
Day,
Or
the
on
town hall's
Tuesday?
gonna be closed.
are we having a discussion or are we making motions?
Well, I made a motion, someone can second it, we can discuss it.
We don't, Carl just wanted to know if we were within the 35 days.
We are.
35 days, we have till October 25th.
25th, right, to close the public hearing. Right?
Right, or
Right.
get granted a continuance. We have time to reschedule.
So, I made a motion
I'll second that motion.
for October 18th at 6 P.M.
Right.
Paige, all in favor?
Aye.
Aye.
Right.
Okay, so it's
6
continued,
At 6 P.M.?
6 P.M., October 18th,
Thank you.
Monday, October 18th. And then we have a little more business here. Correspondence, review revised 2021 meeting schedule for November, our November date is in conflict with the elections, right?
Right, so at this point, I don't know, you could just
So we can
cancel it.
cancel the
We'll just
meeting,
cancel it
why
and
don't we,
schedule a special meeting if we have to.
we can make a motion to cancel the November 2nd meeting and then reschedule if we need to.
So moved.
All in favor?
Aye.
Aye, okay, so November 2nd is canceled, and then if something comes up and somebody wants to come before us, we can always call a special meeting,
Right.
okay? All right, and then approval of September 20th minutes.
All right, good night, folks.
Good night, thanks, Carl.
Good night.
Night, Carl.
On Zoom.
proposal of, approval of the minutes for September 20th. I read through them, I didn't see anything,
They're fine then.
they're fine. So can we make a motion to accept the minutes of September 20th, 2021 as written?
I'll make that motion.
And,
Second.
and seconded by Paige. All in favor? Aye.
Aye.
Okay. Motion to adjourn.
So moved.
So moved.
Second.
Second. Out of here.
8:20.
8:20. Where's mine?